Thanks, everybody, for being here. It is my pleasure to introduce Geoff Charlton, who will be talking to us today about difficulties children face with separating parents. So, Geoff, over to you, and I'll let you introduce yourself.
Thank you, Catherine, and thank you for inviting me here for your 27th anniversary of this organisation. My background, I've graduated in law and practiced as a corporate lawyer for over 20 years, and then as a commercial lawyer for another 10 years. I trained in mediation in 1992, got very quick experience by being involved in the Law Society's settlement weeks that were in 1992 and 93. And for about 10 years, I managed both commercial law and mediation. I then moved full-time mediating in a whole range of fields. And in the last 2-3 years, well, essentially with COVID, I pruned back all the mediation work I was doing to just working for the New South Wales Legal Aid Commission, and that now gives me 1 or 2 mediations a week, which keeps my brain moving. So is that a good enough background?
That's excellent. Thank you, Geoff.
Right. Okay, so the Family Dispute Resolution section of legal aid, they deal with a wide range of separated parents. And that can arise from just one-night stands, separation either before or after birth of the first child, separation after a few years, and certainly separation after long relationships, so up to 20 years. So there's a wide range of ages of children you're dealing with and a wide range of past relationships, if you could call them a relationship. Generally, when a relationship breaks down, the separations are really peaceful, tensions are very high. Separations often result in a single incident of domestic violence where it's not been present before. And of course, where it has been present, then it's most likely. With the people, their feelings are a breach of trust. There's the fear of abandonment, and there's the fear of what the future holds. And where there are young children involved, the feelings are amplified by the financial insecurity of a non-working parent. Now, children pick up on all these tensions between their parents. Where a parent does leave home, the children also feel abandoned along with their parent, residential parent. They're often protective of the residential parent, and there's conflicts in how they feel about the leaving parent. Where parents are involved in their fight with the other parent, they often don't appreciate what impact their fight has on their children. Research has shown that where there is conflict, children are deeply affected by this ongoing argument and even violence that occurs. Now, separation of parents also leads to separation of grandparents, or one side of grandparents, and the children also miss out on that side of the parenting. It's a loss that they feel as well. And where there's been a brief relationship and where there hasn't been too much contact between a child and their father, it's often the paternal grandmother who insists that the son seeks time with the child, even though it may not be so enthused or too knowledgeable about caring for children. But that's another factor that comes into these mediations. Now, by the time that the children have spent time with each parent, and when mediation comes along, that's generally at least several months, if not up to a year, after the separation, the initial separation. And by that time, the parents are in the trenches using their children as grenades. It's not too often that parents are communicating and formulating parenting arrangements. Another factor giving rise to enhanced feelings by one parent is where the non-residential parent forms another relationship, whether immediately or after a passage of time. Where it's a passage of time, often there's been parenting arrangements working well until the new mother comes along. So that's another factor that comes into these mediations. Now, the Family Law Act sets the guiding principle of the best interests of the child being met. And that is the prime focus of any parenting arrangement. And provide the child is kept safe, the parenting arrangements should enable each child to have a meaningful relationship with each parent. The focus is on the child's rights, not on the parents' rights. So that's something that the parents often fail to acknowledge. But provided those family law criteria are met, parents may structure the arrangement in ways that also meet their needs and their particular circumstances. And that's something they don't receive from a judge. So there's an additional advantage in parents going to mediation about their children. Sorry, I'm changing pages. And they're not separating. Right. Okay. Often residential parents who are in argument with the other partner more often don't see the need that their children should spend time with their parents, and they don't see that what a negative impact that has on their children, and it often gives rise to children suffering mental harm. That. Now, the Family Law Act does require parents, whether they're residential or otherwise, to attempt mediation before they commence any proceedings. Mediation is offered by the family centres, and there's quite a few around in the cities, and there's also private mediators as well as the New South Wales Legal Aid Commission. Whatever the intake body, it needs to first assess whether the matter is suitable for mediation. Many aren't. That's because of either a long history of family violence, which would just raise issues of balance of power in any mediation. There's also cases where there's accusations of harm to the child by one or other parent. And that's not an issue that can be mediated. Where a parenting dispute is not suitable for mediation, the intake body issues a certificate which allows the matter to go straight to court. Now, whether or not a matter is destined for mediation, the intake body needs to provide the parties with information as to what public services are available to them, both in terms of mental health and housing and the normal things that you get in terms of monetary support. The New South Wales Legal Aid Commission conducts what it calls a lawyer-assisted mediation. That is where generally each parent is assisted by a lawyer, and that helps to overcome the parents' misguided ideas as to what is their rights in terms of the child, rather than that it's the child that's got the rights. And it tends generally to be a bit more successful than the family centres. So if a party does qualify, then it would be, in my mind, the preferred way of mediating a child dispute. The Legal Aid Commission primarily deals with early interventions. That's matters where it hasn't been before the court, and they also have matters that have been before the Federal Circuit and Family Court of Australia for many years. And often those matters come to the Legal Aid Commission after a family report, which provides guidance as to which way the parents ought to jump in terms of parenting. To get the services of Legal Aid Commission, one of the parents must qualify for legal aid. And that essentially means they've got little in the way of income or assets. It doesn't stop the other parent, who may have many riches, also joining in that mediation with their own solicitor. And sometimes legal aid undertakes property matters as well, where there is a need to divide up unequal property. The lawyer that's engaged by the legal aid client might be an employed lawyer of the Legal Aid Commission, but it may also be just a lawyer in private practice who applies for legal aid on behalf of the client. Now, once a person qualifies for legal aid, the Family Dispute Resolution section of legal aid conducts the intake that I spoke about. And once they've done that, they approach the other parent to see if they wish to participate in mediation. And if they do, they engage their own lawyer, but they need not if they wish to represent themselves. So once the parties have completed the intake and filled in the appropriate papers and have agreed on a day and a time for mediation, the Legal Aid Commission then appoints the mediator from its panel of mediators to conduct the mediation. Now, both the lawyers representing parties as well as the mediator have qualified as family dispute resolution practitioners. This means that they have completed additional family studies, and also their duties are regulated by regulations under the Family Law Act, and the administration of their role is vested in the Federal Attorney General's Department. Now, since COVID, the legal aid mediations initially were conducted by telephone, but lately by Zoom, and from now on, it essentially will always be by Zoom, unless someone hasn't got a computer or a Zoom, can access Zoom, and in that case, we revert to telephone, or it can be a mix of Zoom and telephone. Now, once the mediation begins, the mediator commences with the explanation of how the conference will be conducted. and what opportunity there exists for the parents to reach agreement outside the court system. The matters that are discussed at mediation are confidential, and that is designed to encourage the parents to be open and frank in terms of what they believe is in their child's best interests. It is designed so that, in a practical sense, if one parent makes a concession, but there's no agreement resulting from that concession can't be used in court if it ends up there. At the outset of the mediation, after the mediators finish speaking, the parents are invited to explain separately, of course, what has been happening recently in terms of the children and what they'd like for the future. And out of those opening statements comes the identification of matters that need to be discussed, and those matters become the agenda for the meeting. The mediator's role in all that is an independent and impartial role. It includes the facilitation of the discussions between the parents, and it's the mediator's role to ensure the parents get to say what they've come along to say. The mediator also determines the process that's used, and broadly, mediations can be held face-to-face on Zoom or separately conducted as a shuttle where the parties don't see each other. The method of conducting those mediations is determined from the intake, but the mediator has the capacity to change things if circumstances require it. The lawyer's role, acting for the parents, is to advise and assist their client in the mediation, and also to assess what each parent is suggesting in terms of what a court may order. And that may be the parent that they're not acting for that comes up with something that strikes a bell with the lawyer. 3 hours are allocated for these mediations, which is often enough. Shuttle mediations may carry over a bit longer, particularly if there's an agreement to be settled. As the mediation progresses, it becomes obvious that certain agreements are being reached, and the role of the mediator is to ensure that the parties build on each of those agreements to form a more complete agreement. And that, of course, is assisted by the lawyers who often want to be rid of the client, and so they quickly suggest what ought to be in agreements. And often the lawyers will be emailing each other with draft agreements. The agreements may be in the form of consent orders to be made by a court, and that would require the parties or one of the parties to make application to the court for the orders. Court orders obviously are enforceable if there has been a breach. But equally, there's opportunity for a parenting plan where the parents are fairly determined as to how they feel their relationship should be managed, and in terms of their children, how and when they should have them. So there is an argument that because the parenting plan is not enforceable, that it's not as good as consent orders, but it's not often that consent orders get enforced anyway. If someone brings an enforcement action, normally the judge...
Well? Sorry?
Do you want to put it? I can hear.
I can't.
Oh, okay.
Please mute everyone. Please mute. Vivian, Jane, new people.
Mute. Okay. I'm not far from finishing.
I'm not set. It's all right. Is it interesting?
Yes.
I don't know.
Please mute.
Yes, it is.
Please, can you just put yourself on silent?
All right. Where a matter has been mediated and whether or not an agreement has been reached in the mediation, mediator concludes the mediation by certifying as to whether each parent has made a genuine effort to resolve the parenting issues. And that's a delicate question as to genuine effort, particularly when parents are at loggerheads and are quite opposed to what they believe should be the arrangement for their children. But they may be genuinely opposed. It's not often that you come across a parent who you feel is just playing the game so as to get a certificate to go to court. And that's a rare case, I must admit. Most parents do ultimately participate in mediation in good faith, even if they don't agree. Where a matter is initially assessed as not suitable for mediation, as I said, that enables the parties to go straight to court, and that's often involves high conflict parents. But the court at a later stage may require the parents to go to mediation, normally after a family report has been received and before a hearing of the matter. And there's a high success rate with those high conflict matters that have reached that stage, because the parents are normally exhausted, both financially and mentally, by the litigation, and don't fancy being cross-examined in court. The high conflict parents can be accommodated in mediation by adopting the practice of the shuttle mediation. That's, as I said, where the parents don't see or talk directly to each other. It's the mediator, and often there's the independent children's lawyer that shuttle between the two rooms where the parties are situated. And rooms can be rooms in Zoom. There is a capacity in Zoom to create separate rooms for the parties. The main trick is to make sure you don't put both parties together in the one room. Now, 80% of mediations that are conducted do reach an agreement, even if that agreement only resolves some issues. At least the matter becomes more focused, and the court can deal with those issues more readily. Where there are agreements, that results in children having the opportunity to grow their relationship with each parent. And over time, things tend to settle down between the parents once the rhythm of the agreements occur. There are times when circumstances change and there's a need to revisit an agreement. If the parents are not able to do that, they can again apply for mediation. And I've had parents who have been in 3 mediations that become mediation junkies. But things do change because children grow up. They grow to the stage of being a teen, and they want to decide when and where they go and who they associate with, and mostly they want to mix with their friends. So often non-residential parents need to adapt and accept that whatever may have been the regular time that they had with their child, that it's really in the hands of that child once they become 13 and older. And of course, they cease to be children or subject to the court anyway when they turn 18, and no court's going to order a teenager to go to a parent knowing full well that the teenager will simply do what they want. So things do change, and there's a possibility for more mediation. But the one thing that I have observed in these mediations is that the non-residential fathers often become better fathers than during the relationship with the other parent. And that's because they have to allocate specific time to have the children themselves and to keep them entertained. So I think they end up as better fathers that way. So just in conclusion, mediation has a critical role in restoring peace for the benefit of the children of a divided relationship. Thank you.
Thank you, Geoff. Thank you.
Thanks, Geoff.
Are there any questions at this stage?
Geoff, sorry, thanks for that. That's very interesting. Can you talk a little bit about a lawyer being appointed to protect the children's interest at the mediation level, or is that still not available yet at the mediation level?
No, it's not available at the mediation level.
Mm-hmm.
Independent children's lawyers are appointed by the court, particularly in high conflict matters.
Right.
And once they are appointed, of course, they have a considerable influence over how matters proceed. They particularly can refer a matter for mediation if they think it's going to be worthwhile.
Mm-hmm.
They interview the children, so they're able to transmit to the parents the broad views of the children, and particularly their concerns and worries. They do play a good role. And it is very good when you've got an independent children's lawyer in a mediation with you. You both work together. Mediator's not supposed to suggest solutions, but the ideals tell the parents what they should do.